Want to thank all of you for coming tonight. This has been a collaboration between Nueva Esperanza, Enlace, Neighbor to Neighbor, and the Tenants Union of Western Mass. Neighbor to Neighbor has done a lot of door knocking in the last year, specifically around housing. And the more we talk to people, the more we realize that there is a gap in what we as tenants have for rights, what that looks like on the ground, and what we as tenants know. So the hope is we'll go over some topics that we share, and then there'll be some time for questions and answers. Do you want to say anything?
Yeah, no, so it's just welcome to Enlace. I'm the program manager for Holyoke Massachusetts, the Victim Services Program. You know, there's food in the back, there's snacks. We do have childcare, so if any of the kids need to take a little break and have some fun in there, they can. We are talking about renters and like the situation on that, but we also do have food, so if anyone needs to get a bag of food on the way out, let us know, because we do food distribution. And any other services, they're up here. You can ask Katie, there's Kayla from Nueva Esperanza, JR from the Tenants Union of Western Mass, and Ned, who's helping us record myself. So any of us are the people you can, if you have any questions, come up to us. And I do want to announce, we do have Representative Duffy here with us today. We have City Councilor Juan Anderson Burgos, City Councilor Cocaine Gifner. So these are all, you know, elected officials are not the ones that are going to do all the work, but these are people that you can connect with and contact. Oh, and we have Nate as well from the mayor's office. So.
And then this is Matt from John Bellis' office? Mark.
And Mark from Senator Vilas' office. So.
From where? Senator Vilas' office. Okay. And it's important that our reps are here to see really what's going on the ground, right? Like we live in this state that acts like we're a tenants' rights state, but actually how it plays out in our daily lives is a big disconnect. And we're going to want our state reps to fight for rent control. So it's good to have them here to hear this. So I'm going to turn it over to Maya from the Central West Justice Center, who's going to get us started.
All right, sounds good. Feel free. That's okay. Do you need that one to go too?
Yes.
Okay, go ahead. Do you want to take that? Can you bring it for? Yeah, thank you. Okay.
Thank you.
Everyone can get settled. I don't want to start talking too early, but just wanted to begin by introducing myself and my colleague who is helping to arrange the room at the moment, but we'll be back up here to talk. My name is Maya McCann. I'm an attorney at Central West Justice Center. If you haven't heard of Central West Justice Center, we're an affiliate of Community Legal Aid. At Community Legal Aid, we represent low-income and elderly members of Central and Western Massachusetts in a variety of civil legal issues. And at Central West Justice Center, we do the same. Some folks might think, you know, that they may be ineligible for some services at legal aid because of immigration status or things like that. So I also wanted to point out to you that while there might be some eligibility restrictions at some of those programs, Central West Justice Center can take you regardless of immigration status. So please don't ever hesitate to call based on that preoccupation. So the project that I specifically work in is the Seasonal and Migrant Farm Worker Unit. We work with folks who are farm workers, have farm workers in their family, have worked on farms. But the main area that I work on in my project is housing, but we do represent folks in a variety of civil legal needs, including immigration, because it's a holistic model, and we know you don't just struggle with one problem at a time, right? Everything kind of intersects and it all happens at once. So that's kind of why we have that model. And Nuri, I'll turn it over to you to introduce yourself, and I have the microphone, so I'm just going to stand right next to you.
Fantastic. Thanks, Maya. I'm Nuri. I use they, them pronouns, and I am the Fair Housing Testing Coordinator with the Springfield Fair Housing Project, which is a project at Community Legal Aid. My unit works specifically on fair housing issues, which is really hard to define, but basically we work with housing discrimination and housing discrimination laws, both mostly within the federal laws, but we also work on state claims as well, state discrimination claims as well, which can differ from federal protections. So that's the work that I do. And I do fair housing testing, which if you want to know more about it, I'm very happy to talk about it later.
Cool. Okay, so we are going to run through some of the topics. Oh no.
Oh, no.
Help me. We're going to run through some of the topics that were brought to our attention that folks had interest in, but we also want this to be collaborative, so we want to hear from you. What are you struggling with? What questions do you have? How can Community Legal Aid and Central West Justice Center be a resource to you? So we're going to save plenty of time for that at the end. This presentation will be in English, but we have Spanish slides so that it can be a resource that you can share with other folks after. If you ever need me to slow down while you interpret, just let me know and I will do that. I tend to talk fast. So we will jump in, but if you have questions, we'll leave lots of time at the end. This is going to be kind of an overview, a 101 of sorts, so if there are more specific things that you want to talk about in questions and after with one of us, we're happy to do that. And there's some other lawyers in the room that will talk to you as well if you want. Okay. The first thing that came to our attention is folks were really worried about what happens if they have bad conditions in their home. So, the first thing I want you to know is that you have a right to a decent place to live. Conditions are things that you have a right to. So I'm going to put it on the Spanish slide, but you guys can hear me talking in English. So your right to a decent place to live is partly based in the state sanitary code. So you can find this, there's copies up here of the Mass Legal Services Booklet 2, which is your housing code checklist. This checklist is offered in a bunch of different languages on Mass Legal Services, and I put the link, but we can help you get access to that if you need to. And it walks you through the minimum standards that your apartment has to follow. And there's also this great tool that GBLS, Greater Boston Legal Services, created called Made Up to Code that helps you document the conditions in your apartment so that you can keep track of repairs and how things are being made. So, if your apartment does not comply with this code, so it's helpful to read the code to see what it's supposed to follow, but if your apartment doesn't comply with the code, the first thing that you can do is tell your landlord. As a tenant, you have the right to tell your landlord when things need to be fixed, and your landlord should not retaliate against you for complaining about bad conditions. So please don't hesitate to let them know when things need to be fixed. Our advice, do it in writing. If possible, that includes text messages. Some people are like, does it have to be a formal letter? No. Text messages are fine. Emails are fine. Or if you told them in person, write it down after the fact so that you have documentation of that for later on, and then save them somewhere. Whether it means screenshots on your phone or a file where you keep everything, make sure you're keeping track of those for later just in case. Take photos, take videos, keep track of all of the conditions as soon as you notice them and as things progress. So if your landlord comes once to make a repair, you can take a photo after the fact as well. So keep good track and also write down when you took the photos. That was a good reminder because sometimes you may not have that evidence depending on what kind of camera you took it with. Okay, so the big question is, what if my landlord wants to come and fix things? So your landlord should tell you in advance. They should give you reasonable notice for when they're going to come and make repairs. Reasonable usually means more than 24 hours, unless it's an emergency, like water's gushing into my apartment, they should be able to come in right away. Otherwise, they should tell you at least 24 hours in advance. But you also have the right to ask for a different time. So I know a lot of us will want to be there when our landlord is there, or maybe you don't want your kids home alone or something when the landlord comes. So you have the right to ask for a different time. Just make sure you're doing so reasonably and offering lots of alternatives and trying to work on it together with your landlord. If your landlord doesn't make repairs, you've been asking and they're not fixing something, what do we do? So if this happens, you can call the Board of Health. So you have the right to call the Board of Health, your code inspectors who will come, and you can ask for a comprehensive inspection. So they should come and look at your apartment and document all of the violations. Some things we recommend when this happens, it's helpful to be there and point things out. So you are your best advocate, right? So you want to show those inspectors, this is a problem, this is a problem. Don't assume that they're going to see everything that you've been dealing with because you live there. The other thing is, and this is hard to talk about, but if you're having mouse droppings or something, you might be a kind of person that wants to clean it up a lot. If inspectors are coming, maybe leave those mouse droppings so that they have evidence. Because if that's the only proof of mice who are fast and they hide, the only way they're going to know it's a problem is if they see it. But otherwise, it's helpful to clean up things like you don't want to have food out or entryways obstructed. Things you have control over, those things you can clean up. But don't hesitate to leave some evidence and point out that evidence. The other thing you can do is you can go to housing court. So housing court does feel scary. Court can be scary, and we understand that, but housing court should be the resource for you. It's a resource where you can go in and you can ask for help. You can talk to court staff. You can talk to the lawyer for the day. We have lawyer for the day every day of the week on Zoom right now, and Thursdays in person, and tell them what you're dealing with, and they can help you figure out your next steps. Maybe it means you file an emergency order to get your landlord to make repairs, things like that. So the housing court is a resource for you. Okay, same thing in an emergency. If there's an emergency in your house, you don't have heat, you don't have hot water, things like that, housing court is your resource. You can go in and you can file an emergency order, and people there can help you figure out how to do that. There's also a lot of great tools that we can sorry, Katie. Tools that we can show you online for how to file an emergency order. No, that's fine. Yeah, we can. The only other thing I want to point out is if your apartment conditions are really, really bad, there is a chance that if the Board of Health comes, they could condemn the property. So it's something that you should just be aware of, because condemnation means you have to leave right away. If you have to leave right away, you might need to have a plan for where you're going to go, but you should also ask the court for help. Ask them to get put up somewhere. Sometimes they'll do it. It's not always a guarantee, but you should always ask the court to fashion remedies that work for you, and advocate for yourself on that. It's just something we want you to be prepared for when you call the Board of Health if things are really bad.
Can you just explain a little bit what it is from, like if the Board of Health comes to condemn your building, what kind of happens? They hand you a paper and say it's condemned, and then what?
Yeah, so if your unit is condemned, the Board of Health will come. Basically what they're saying is it's unfit for human habitation. That means that they don't think people should be living there. So they will give you an order to vacate, which tells you usually when you have to leave, and it's pretty much immediately. And they will bring your landlord to court. So if there's a condemnation, the Board of Health or the city will sue your landlord and bring them to court. And in court, that's where you can ask the judge, I need to be put up, I have nowhere to go. And then that case will continue, and the city will be working with your landlord to get them to make repairs and try to get you in as quickly as possible. What are my rights if my landlord tries to evict me? So we're going to move to the next section, but if you have questions about repairs, condemnations, and things like that, we can talk later, or I can answer now.
Yeah, I'm going to be quick, and it's more of a recommendation.
Okay.
If you're going to keep the rat droppings, I would suggest putting it in the container and not leaving it out.
Yeah, so it's not
so
safe.
unsanitary.
Yes.
Could you please repeat that?
Yes, of course. So my recommendation is that if you want evidence that there's mouse droppings, do not leave them out in the open. Put them in a container because it's safe for children, or safe for children, and safe for just anywhere being near.
Exactly. That's a great addition. Yeah, thank you. Exactly. And also photos. You can show the Board of Health photos. So if it's a really bad problem or it's out and exposed, take pictures, write down when you took those pictures, and tell the Board of Health, I cleaned this up, here's when I cleaned it up, and here's evidence. That will help them document it as well. The Board of Health is your resource too, right? So you should continue to be in communication with them. If your landlord's not making repairs by the time that they said they're supposed to on the report, call them. Tell the Board of Health. Don't make them be the ones to do it, because as I keep saying, you are the best advocates for yourself. We can see that here. You're here. So make sure that these services are working for you the way that they're supposed to. Okay, so what happens if you're facing eviction? Okay, So the most important thing I want you to know is that you have a right to a full court process. Too many people, when they get a notice to quit, which I'll describe in a minute, feel like they have to leave right away, and then they don't end up using the full process to assert their rights. And in fact, you have a lot more time than you may think that you do, and a lot of rights and resources that you can assert before the end of the process. And honestly, tenants can win these cases, you know? So it makes a big difference if you enjoy and take full advantage of the process. So your landlord cannot just make you leave unless they've gone to court, gone through this whole process, and gotten permission from the court to make you leave. And that takes a very, very long time. So this is a description of the process. I'm going to put it on the Spanish one, but I will walk you through what the process is in English. So the first thing that you get is a notice to quit, which is a weird word, but basically it's a letter that you get from your landlord. It might say notice to quit, might say something else at the top, but usually it says that you have until a certain date to leave your apartment, that your landlord seeks to terminate your tenancy. This is the necessary first step of an eviction. They cannot file in court without sending you this notice, so you have to make sure that you get the notice. And there's a lot of rules that the notice has to follow. I see a question in the back, yeah.
And if they wanted you out for a certain amount of days, like February 28th or something like that, and do they have the right to change the locks on you?
Absolutely not. So the notice to quit is a required first step, but all it does is gives the landlord permission to then file in court if you choose not to leave. And then, like I said, there's a lot of things that happen in court where you can continue to assert your rights. So they can't come in, they can't change the locks, they can't threaten or intimidate you to try to get you to leave.
And if they do, what are the actions you gonna take?
If they change your locks,
Yes.
you go to court. Or you call us. You know, you should always call a lawyer. We're way more accessible than people may think, so call a lawyer. If you can't get a lawyer, go to court. There's a lawyer for the day in court, so you tell them my locks were changed and I can't get in my house, and they can help you with something like an emergency order, something like that. If you can't get a lawyer for the day, you can do it yourself, and the court staff are really helpful. There's also forms on Mass Legal Services, which we can show you how to access, and also Katie can show you how to access, that describe what you can do in this situation. Yes, in the back, and then.
My landlord, he keeps harassing me because he's seen us on, he's seen me and my neighbor on the news at the city hall. He keeps bothering us about it.
We're definitely going to get to that after. I think that might be in our section at the end. So we're going to talk more about what's okay and not okay there. And then if you have specific questions and specific concerns, we would want you to talk with a lawyer, probably yourself, about your certain case. So we would do that after. Okay?
He's dealing with the state right now because I went to the Board of Health for a lot of things that need to be fixed. Mouse infestation, I have illegal heating.
Yeah. That sounds really, really horrible, and we definitely want to make sure that you know that retaliation is not allowed for a lot of these protected activities.
He's telling us if we call the Board of Health that he's going to kick us out.
So we're going to make sure that you talk to one of the lawyers before you leave and figure out how you can call to maybe do an intake, okay? We'll do that at the end. Yes.
Are there specific reasons for why I might get a notice to quit?
Yes. So you can get a notice to quit. There's basically 3 different ways that your landlord could seek to evict you. The first one is no cause or no fault. The landlord, there's nothing you've done. The landlord just needs the property or wants you out for no reason, basically. You can get one for cause or for fault, which basically is claiming that you violated your lease, a provision of your lease or your rental agreement. Or you can get a notice to quit for non-payment. So that's your landlord is alleging that you have not paid the rent. After the notice to quit, in a non-payment eviction case, you do have the right to cure. You might have the right to cure based on whether you have a lease or not, and based on whether you have the money or not. So that gets a little bit more specific, but if you have the money for the rent and you're able to pay it before your landlord files, you might be able to avoid the filing of the eviction. Or if they file the eviction, you might be able to pay what you owe and then have the case dismissed. Yes?
What about for all the traumatic of going through the process and putting you through this headache or just post-traumatic or depression or whatever, can you kind of sue them? Can you sue them through the process? I mean, since they're taking you to court, is that the process where you can sue, or you have to wait till it's finished to kind of sue?
So it depends on, if you're trying to just get the case dismissed because you've paid everything that you've paid, you probably wouldn't be able to bring those claims. But if you're going to go forward with the eviction case, you can bring, there's a way to bring counterclaims in your eviction case. So we're definitely going to get to where you would raise those. Okay, so the next step is, if you haven't left, when you've got your notice to quit, what you'll get in the mail is called a summons and complaint. And this paper basically alleges what your landlord is saying, why they want to evict you. So if they're saying you broke a rule, they'll put that there. If they're saying you owe money, they'll put that there. Thank you. And if they're saying you haven't done anything, it would say that as well. It'll have the court where the case has been filed, and that you have to go to court. You'll get a notice mailed separately to you about your first tier event. So basically what that means is you're going to have to go to the court to mediate with your landlord. It's a required first step in evictions. You have to show up for this or you'll be defaulted. What that means is if you haven't shown up, the court will just issue a judgment for your landlord. There are ways to remove it, but it's very important that if you get a notice from the court that tells you when to show up for a mediation, that you go. This is also a good time to call legal aid. If you get a notice to quit, but immediately you should get on the phone and call the number, which we will put here and is there, and call a lawyer and see if someone can help you. And if you can't do that, remember that there is a lawyer for the day in court, and you should ask to see those people on your day of the hearing. Now that you have a summons and complaint, the next step is the answer, discovery, and jury demand. So the answer is where you get to do exactly what you were saying. You get to raise your defenses, which are reasons why you think you shouldn't be evicted, and your counterclaims. So anything that your landlord has done wrong or in violation of the law, you can bring those in the case. And we'll talk more about that on the next slide, specifically what are some of the things you can claim. But there's a lot. Tenants do have a lot of rights, and you should assert everything that you can. And then at this point, you can also make your jury demand. This is a great idea to do because if you don't assert it at this point, you might lose it. So we always recommend that you assert your demand to have a jury hear your case if you do get to trial. It's also possible that it could get you some more time. Tier 1, as I mentioned, is the mediation that you will have with your landlord and a housing specialist. In a lot of instances, tenants can come up with agreements with their landlords that do work to resolve the situation. Maybe it's a payment plan that includes that the landlord will make repairs, something like that. Don't feel pressured at this stage to agree to something. We want to make sure that at this stage you are talking to the lawyer for the day, or have a lawyer, or have gotten some advice. But the most important thing to do is not just sign an agreement because you feel like you have to. We have this whole process. You have the ability to raise your defenses, to talk to a judge, to ask for help. So don't feel pressured, even though it can be a really tense and stressful situation and you might feel like you don't have power. You do. So we don't want people agreeing to things and then leaving court if they can't comply. Because if you do agree, for instance, to a payment plan and you sign that paper and then you can't follow that payment plan, your landlord can then come in and ask for an execution to have you removed. So it's really, really important that you understand what you're agreeing to and you know you can comply. If you progress to the next step, that would be your trial. The housing court does see a lot of tenants that don't have attorneys. We want you to keep trying to contact legal aid. We want you to keep trying to talk to the lawyer for the day. They help tons of people every day, so definitely ask for help, especially if you have a trial. But you can do it yourself. So it's really important. All you need to do is make sure that the judge understands what's happening in your case, that they understand the reasons you think you shouldn't be evicted, and any claims that you want to bring against your landlord. You should bring all of your evidence, everything that you have, and talk to court staff and see if they can help you figure out how to make sure that the judge sees that. Photos, all those texts we told you want to be saving, everything like that, so that the judge really understands. The landlord will get to say their piece, you'll get to say your piece, and then the judge will decide. The other two things we want to point out really quickly are, if you do go to trial, keep an eye on your mail. When you get the decision in the mail, you only have 10 days to appeal. So as soon as you get that decision, you call legal aid and go to court and file an appeal if you think the decision was wrong. And you can maybe get some more time. You could maybe get the decision reconsidered. Similarly, if you do get an execution, those 48-hour notices that says you have to leave, you can get a stay. So you should definitely go to court and tell the judge why you need more time and ask for the ability to get a stay so that you can figure out your next arrangements. So all of these things that I just spent the last time talking about have to happen before you can leave. So you don't feel pressured to leave when you get that notice to quit. That's why I put it in this bright yellow star.
Yeah. What happens in the situation if your landlord passed away? What would you do?
If your landlord passed away, just in general or during an eviction case? Just in general?
Yeah.
That's an excellent question, and I'll have to think about it and get back to you. We will talk afterwards, okay?
Thank you.
Yes?
Well, they will face another landlord because of that.
Yes, most likely.
It happens. The landlord was not working anymore, so there was another landlord
Yeah.
less than a week.
But definitely, it's like, if that has happened, you should talk to a lawyer and go to the court and see if there's something you need to be doing to figure out who's in charge of making sure you have a habitable premise and who you're supposed to be paying rent to and all those things that are requirements of being a tenant. The other thing I want to point out is that if you are being evicted for non-payment or you're having trouble paying your rent, you should apply for rental assistance. We will explain how to do that after, but if you apply for rental assistance and you have a pending application for rental assistance, you cannot be evicted. So it's really important to apply. When you fall behind or if you get one of these notices, apply right away for rental assistance and then make sure you tell the court and the mediator that you have a pending application and they can, continue things and try to wait till that goes through. Oh, we got it. Okay. The other thing that's important to know in evictions is you have lots of rights and resources and you can preserve your home. There's a lot here. I don't want to talk for hours and hours and hours about all of them. So I'm just going to mention the most important ones and we can talk more in depth. And if I'm forgetting something or you want to point something out, let me know. So as I mentioned before, your defenses are reasons you think you shouldn't be evicted. So it can be as simple as they're saying you broke the lease and you don't think you did. You tell them that. I deny that I broke the lease. I did not do what you're claiming that I did. Alternatively, as we mentioned, there's all these rules about how to serve the notice, when you can file in court, all of these things. If your landlord did those wrong, that's a defense to being evicted and you can put it in your answer. And a lot of those things, if they've done it wrong, the court will dismiss. Retaliation, if you think you're being evicted because you've done something like call the Board of Health or joined a tenants association, you're not supposed to be evicted for these reasons. So make sure you include those in your answer and it's a reason to have it dismissed. And then counterclaims. So this is where, as you were mentioning, if there's things you want to bring against your landlord in an eviction case, you can list them in your answer and bring these counterclaims against your landlord. So for instance, if you've had really bad conditions, those are violations of the state sanitary code. They also could be violations of something called the Covenant of Quiet Enjoyment. They could be violations of Chapter 93A, which is the unfair and deceptive business practices. Mass Legal Help has an answer form that kind of explains all of these things and helps you figure out what things you should check and what things apply to your situation. But those are all things you want to raise, because if you have been dealing with these problems, not only do you have a right to get them fixed, and your landlord should be held just as accountable as you are if you fell behind in your rent, but also they can be reasons that you don't get evicted. So if your landlord ends up owing you more money than you owe them, you want to assert all of that here. Yes?
What about if it wasn't about the money? They just didn't want to renew the lease.
For a no fault.
They didn't want to tap into the, to raise up the rent prices.
Yeah.
Just because employee woke up one day and say, you know what, this guy has too much to fix this, fix that. I don't even want to renew his lease. You know what I mean? And she did that. How would you handle that situation?
So that's a situation where, it depends. Landlords are allowed to raise the rents because they're in the business of renting, and is what it is there. But that doesn't mean that what a specific landlord does is okay given whatever circumstances kind of surround that decision. So if a landlord is raising rents and then serves notices to quit, gives notices to quit, but only to people with rental assistance, that could be a discrimination claim, that they are treating individuals differently because of their source of income than they do other tenants of the building. So it depends, and that's one of those situations where you want to speak to a lawyer about what the heck is going on and what your options are in response to that.
Especially if you feel like, as you just said, it's because you've made complaints about things that have been broken constantly, but things are constantly broken, and you feel like that's why they're bringing this eviction. That's a good thing to explain here and give your reasons for and talk to a lawyer about. The other things, there's a lot of detailed rules about utilities and when your landlords can charge them, can make you pay for them. So you have to have an agreement that tells the tenant that they're responsible for utilities in order for the landlord to make a tenant pay for those. And then there's lots of detailed rules about security deposits that often landlords get wrong. Your landlord's supposed to put it in a separate account. They're supposed to give you a receipt that tells you where it's stored. They're supposed to pay you the interest, and they're supposed to return it within 30 days. And then there's also pretty detailed rules on what they're allowed to use it for at the end of your tenancy. Again, Mass Legal Help has a lot of rules on that, so if they've violated that, that's another counterclaim you can bring. There are lots of others, and I do recommend checking out some of these websites that I'll talk about in a second that can help you see which ones might apply to you. There's also other strategies. So you can work with landlords. Some of them are willing to negotiate. Some of them don't necessarily want to get rid of you. They're just trying to figure it out just like you are. Not all of them, but some of them. So it might be possible to enter an agreement with your landlord that does work for both sides. You also, as I mentioned before, can apply for rental assistance and get the landlord paid back. And some rental assistance requires that the landlord dismiss the case once they're paid in full. You can also ask for reasonable accommodations. So if you feel like your eviction is based on a disability or a manifestation of your disability, and instead of kicking you out, your landlord could keep you with an accommodation, you can ask for that. And Nuri's going to talk a little bit more later about what reasonable accommodations are and how to ask for them. And then there's all these resources. So as I mentioned a bunch of times, call legal aid when you're having issues with your landlord. You also can go to your tenants association and all these wonderful organizations that are here to support you. They can give you information, they can accompany you, they can help you figure out what your options are and your rights are. I just heard Katie giving a whole spiel of great advice, and she can help you out with those things as well. You can go to court and get help in court. You can get help from the lawyer for the day, the personnel in court, court staff, the tenancy preservation program. And then there's all these great tools that have come out in the last few years as we get better at providing accessible information to tenants. Mass Legal Help, which I've mentioned a bunch of times, has a bunch of forms and booklets to help you know what your rights are and then help you walk through an eviction case. How do I do this form? What is an answer? And how do I know what applies to me? And they can help you with those things. And then MAID will walk you through what an eviction would require from you and help you produce the forms if you are in the situation where you have to do it yourself. Yes, I saw a
I
question.
just want to highlight that some of these forms are here, some of these resources are right here. So if you walking out, you can't pick some of these up.
Awesome. Yes.
Hi. I was just wondering, so let's say I have an issue with my landlord. When you say you can go into court and talk to someone from legal aid, do you literally mean like I can just go to the courthouse behind City Hall, walk in and just start poking around?
Well, so so Lawyer for the Day is virtual every day except for Thursday, so you'd have to find them online, and I can show you how to do that, but they can also connect you with them in the courthouse. Thursday's Lawyer for the Day is in person, but there's a lot of folks there, so they might need to triage people who have a trial that day, but it could be worth going to ask.
Lawyer
Yes.
for the Day is only from 9 to 1, I believe, as well. So if you go after 1, Lawyer for the Day is over, but otherwise, Zoom or in person on Thursdays.
And we can make sure we can get you this information.
On Main Street, right where the waterfall is, you go in that one on the 3rd floor, they got legal aids there.
Yeah, that's our office. You can walk in, you can call, or you could go online.
Also, you would have to go to the Springfield Housing Court, not here in Holyoke.
Yeah, thank
Down
you.
at Court Square, it's, the district court is there, and then housing court is in front of it.
It's like an old building. But yeah, we will make sure that we share with you all these resources so you can, know where to find Lawyer for the Day and stuff. But if you're trying to find legal aid to see if you can get a lawyer to represent you, you should call, go online, or come to our office. The court is just in emergencies or to contact Lawyer for the Day.
And just an additional point about Lawyer for the Day, that even if a lawyer can't take your case or for some reason does not take your case, they can still guide you in what your options are or what to do. So don't be discouraged if you're like, oh, lawyer's never going to take this. Like, they can still help you out.
Yeah, exactly. It's always good to ask for help and for advice.
I'm sorry, because I'm also a victim of eviction, so I took this as a personal attack on my family because I got a 2-year-old. And you said that if the housing actually supported and paid whatever balances, I'm withholding rent from them until they fix certain things in the porch or inside the mold or whatever. And like, I don't want to drop it. I want to hold them accountable, or I want them because the mouse just ate the cables of the refrigerator and it's leaking, ate all this food, or I can't even put food in the pantry where food is starting to be thrown outside because
Those are bad conditions that you shouldn't have to deal with, and I understand your frustration,
so, I don't want them to throw it away even though they get paid. I want to hold them accountable since they target me out, because even though I'm a leader in the community, it helped his property, so he won't get sued. But this is the thing, second, but it's not even my landlord who even dare to tell me to evict me. It was his assistant, I guess. I don't know if she's trying to get a raise, but I want to make an example out of it.
Yeah, so definitely, I think you should talk to one of the lawyers either after this or call the intake line, but you can bring cases against your landlord outside of an eviction. So, unless you've already brought those claims before, which we can talk about like through an eviction case, a tenant can file a complaint against a landlord for bad conditions, and we can kind of talk a little bit more about that after, once we get through these topics. But you have rights, and those laws protect your rights, so you can bring a case against them for damages and also to get things fixed.
Yeah, I got a question for you. I'm in a shelter, right, and I apply for apartments all the time. I have a Wayfinder's voucher, which it gets turned down most of the time because these landlords refuse to take them.
That's a great question. We're about to talk about that. That could potentially be a case of what's called source of income discrimination, which is not allowed under state law. So if you are experiencing that, and landlords are just saying, that's when landlords say, I don't take Section 8, they are not allowed to say that. So that's definitely I would love to talk to you more about that as well after. Somebody back there have a question?
Can they Can they evict you if they haven't even given you a renewed lease and they're asking everybody for rent, knowing that they're supposed to be fixing, but they're not fixing nothing?
It
They've
depends.
had plenty of fines, they've had Board of Health
You
in
have to
there.
petition that, you have to petition that and bring it into City Hall. Because if you don't petition it as a group, you won't get nowhere. One person alone can't fight against one landlord when you got money and got lawyers. You need a whole group to fight that.
Yeah, my whole building is, because none of us have a new lease. We all have a mouse problem. My heat is illegal. Nothing in that building is up to code. The Board of Health has already been there. I have a lead. I had a lead issue.
So if they are bringing eviction cases and you're dealing with all,
For rent and
Mm-hmm.
I'm not giving him no rent.
if you're dealing with all of these problems and they do try to evict you like you asked, these are all examples of these counterclaims and defenses. So you should make sure that you're, first of all, calling attorneys and talking to them because these are big problems.
My husband had applied for Section 8 and they told him, let him give you an eviction notice. You'll get your Section 8 a lot quicker if you take him to court.
Sorry, yes?
I have 2 questions.
Okay, go ahead.
Can I withhold rent if I think my landlord's not doing what he's supposed to? And do my tenant rights apply if I live in public housing?
So there were 2 questions there, and I'm not sure that everybody heard them. The first is, can I withhold rent if things are, oh, sorry, yeah, I'm not. Can I withhold rent if there are bad conditions? And the second was, do my tenant rights apply if I'm in public housing? I'm going to start with the second one. Yes, you have tenant rights if you're in public housing. Public housing tenants should be given a pretty detailed lease that contains a lot of rights and provisions in addition to these other ones that we've been discussing. So things like a grievance procedure, raising rents is much more difficult under subsidized tenancies, so they have to go through a lot of different processes that they have to follow, so you should know what those are and make sure they're being followed. So the simple answer is yes. The first question about rent withholding, it is very difficult to properly withhold rent, so it's something that we advise a lot of caution about. And if you are thinking about withholding your rent, it's really, really advisable to talk to a lawyer. Just because there are so many requirements to withholding it properly under the law. And it's most likely that your landlord will try to evict you. So if they file a case in court, you will have that record show up. And then if you haven't saved all the money or you haven't followed all of the rules, it just can be really risky. While you do have that right under the law, it's something that we advise you proceed with caution and talk to a lawyer about how to make sure you're doing it properly so that you're not jeopardizing your tenancy. We know how hard it is to get apartments right now, so we just want to make sure that first and foremost you're housed. Especially if you have a Section 8 tenancy or a voucher, it's really can be risky, so make sure you talk to a lawyer. And if you call legal aid, for instance, and they aren't able to take your full case, there's a chance they could help you get advice or refer you to private lawyers. You can call private lawyers to talk about it. And there's a lot of information, as they've pointed out a bunch of times, online about what exactly the rights are, what the rules are, and how to make sure you're doing it properly. Yes?
Can you go through some details with us here about a month-to-month situation? Because there's a lot of landlords, in particular since the pandemic, that are not doing 12-month leases with people. They are doing month-to-month. And I think that people don't really understand. A lot of times there's not anything written with the month-to-month. So if you could go through a little bit more detail.
Even with mine and the phone.
Yeah.
We still don't have a lease proving what we're supposed to pay.
Yeah, what I will say is whether or not you have a lease, the rights that we've been talking about still apply. So sometimes people may not think if they, if there's not something written down, maybe they don't have all the same rights, but that's not true. So you still have all these same rights. You still have to follow the same eviction process. So that's important for you to know. Anything else you feel like?
Sometimes a lease that you've signed in the past kind of automatically after 12 months turns into a month-to-month tenancy. And that you should look in your lease to see if there's any language that governs that month-to-month tenancy, but just underscoring that whether or not your lease is written down, whether or not your lease is for 12 months or 6 months or month-to-month, you still have housing rights, and your landlord still has to follow the law. Yes. So I'm going to move on to discrimination really quickly, and we can get to other questions later. So housing discrimination, I think I'm okay. Yeah. So housing discrimination is governed by 2 laws here in Massachusetts at any rate. So we have the Federal Fair Housing Act, which is on this side, and apologies for the formatting there. That's great. And then we also have Massachusetts law that adds additional protections. So housing discrimination happens when a person is denied equal opportunity to access to different provisions in their tenancy from others on the basis of particular categories. So a lot of people experience not great treatment by their landlords. To fall under fair housing laws, that treatment has to be connected to protected classes that you see listed here. So classes like race, national origin, sex, domestic violence problems that you might have experienced, familial status, so if you have a child under 6 or if somebody is pregnant in your household, disability, all of those and more. Massachusetts has expanded protections as well. Those are just federal protections, examples of federal protections. If the housing action that a landlord is taking, they're doing it because of your immigration status, for example, that could be a discrimination claim. That would fall under the discrimination laws. So an example, if your landlord is refusing to make repairs to your apartment, and they're saying, if you call the Board of Health, I am going to call immigration. They can't do that. 1, they have to make repairs, as we've just heard. And 2, it has now become a housing discrimination problem because they are telling you that you can't you can't exercise your rights under the law because of a protected class, which would be your national origin. And more, potentially. So look out for those things. That's something that you're going to want to talk to legal aid about. The Springfield Fair Housing Project, which lives in the same Springfield office as Community Legal Aid. We will be happy to talk to you about what the heck is going on. So we've got that. There are a whole slew of prohibited behaviors that a landlord cannot do that fall under the discrimination laws. So things like telling you a different rent when you're looking for housing. Telling one person that the apartment is $1,400 a month, but telling you that the apartment is $1,700 a month, if they're telling you that because of your pick a protected category, your race. They cannot tell you that housing is not available when it is, if they are doing that on the basis of your race or whatever other protected categories, gender, sex, gender expression, all of those things. They cannot change the terms of your lease because of any of these things. So one major issue that we're seeing more, which I think just speaks to people's comfort in coming to us and not necessarily that it doesn't happen or it's now happening more, but quid pro quo agreements. So if a landlord, if you're behind on your rent, for example, and a landlord comes to you and says, you know what, if we just spend 5 minutes in the back, I think we can forgive. It's okay. We'll be squared up. That is not okay, and that is a form of discrimination under the law. That can't happen. All these examples of things that a landlord can't do, and certainly a landlord can't evict you because of any of these protected classes. One major thing that we see a lot is discrimination on the basis of disability. Often that comes in the form of denying what's called a reasonable accommodation request. So your stereotypical example might be if you have an emotional support animal and your landlord says, no pets, we don't take pets. That's, no, thank you. That is a form of disability discrimination because they are denying you your disability aid and they are not making an exception to that rule. What a reasonable accommodation request does, in essence, is ask for an exception to a rule based on your disability. So we see if an individual is being evicted for lease violations, and the reasons that they violated their lease are connected to a disability, say a mental health disability or something like that, or a physical disability, anything like that, that could be a defense to eviction if you ask for an accommodation based on your disability. And then you would kind of engage in a back and forth with your landlord about what that might look like. In order to make a reasonable accommodation request, there are a couple of different things. If your disability or a member of your household's disability is apparent, so if somebody can tell this person is in a wheelchair and they are asking for a ramp, they do not need additional medical information about your disability. That is enough. They do not need a doctor's letter if that's the case. If your disability is not readily apparent, say you're seeking an exception to the no pets policy because you have an emotional support animal, you would need verification from your doctor, your therapist, somebody that can verify that you have a disability and the ask is related to that disability. So that's the key there, is that whatever you're asking for has to be related to the disability. There's information online about what those letters can look like. Some housing authorities offer like verification forms that a provider just signs. The definition of disability under the fair housing laws is pretty broad. So you also don't need to be disclosing your entire medical history to your landlord. They do not need to know any of that information. They just need to know that you have a protected disability and that you are asking for a modification or reasonable accommodation based on that disability. That's what they need to know. What other things do I want to say about discrimination? Discrimination isn't always obvious. It is in cases where a landlord denies your reasonable accommodation request. It's easy to tell that you have been treated differently because of a disability. But sometimes it can be really subtle. So when you brought up that you've been looking for 4 years on a voucher for housing and you keep being told that there's nothing available, or people keep saying no to that, sometimes you don't know that what the reason is that they're denying your application or anything like that. It could be for discriminatory reasons. A lot of individuals and a lot of communities have been told that what they are experiencing isn't real, or you're not being denied because of X. I am playing by the rules, and the Community Legal Aid Springfield Fair Housing Project, we would rather you trust your instincts that you've been mistreated and come talk to us so that we can kind of discuss more about what is going on, than you thinking like this is just how it should be, because that's not the case. There are laws that are there to protect you. Screening tools, online screening tools have become a really big problem too, where people are just screened out of the application process before a human person even looks at their application because they don't meet whatever criteria some landlord has put in place. And if those criteria affect particular communities differently, and those communities fall under these protected classes, that could also be a discrimination claim that you might have against a housing provider. When somebody is experiencing housing discrimination in their rental search, for example, and they have experienced discrimination, there are ways that you can take action to access that apartment. Some people really don't want to rent from somebody who's discriminated against them, but the nature of the housing market is, as you are all aware, it's just ridiculous. And so when people find apartments, maybe they really need that place because there's literally nothing else. So you can talk to lawyers or go to the court, and there are options for you to kind of possibly access those.
Landlords do make it impossible for people, because me and Teresa, last year, we went to Sokaniki to apply for an apartment. She was a witness. They asked us everything but the color of my underwear. All right?
Yeah.
They were asking for bank accounts. This.
Oh my goodness.
Well, you know, that's
Yeah.
personal information. We should,
Yeah.
if we can afford the rent, we have a voucher, you know, we should be
Yeah.
able to get this apartment. Why are you gonna put us through the ringer? It got me so upset that I said, you know what, you can keep this shit.
Yeah. So that's, I mean, that is a major problem. There are some legal reasons. I put that in air quotes. There are technically legal reasons. They are awful. That a landlord can deny an application. Credit score. A landlord is technically free to deny an applicant because of their credit score, even though we know that credit score doesn't do anything to determine a person's ability to pay their rent, especially when they have a voucher. But it's legal, technically.
Listen, I'm glad you brought that up, because there is apartments out there, but they require 3 times the income.
That is a, yeah. So, yes, yep.
Or not.
So,
For the president.
I'm telling you, that's the issue right
Yep.
there too. They are holding these apartments.
Yes.
Like Whitman's or property management. That's why
Yes.
they find all these property and
Yep.
they just play cops. I mean, they're a bunch of thieves the way they bracketing and stuff.
Yes.
And they doing a gentrification is what they doing right now.
Absolutely. So,
That's very
yes, it absolutely is. So when you see that language in rental ads, requires 3 times the monthly rent to be eligible, employment verification. That is not, you can't do that, because that is a source of income discrimination problem under Massachusetts state law, because it just is. You don't have to be employed. Your source of income does not have to come from a job that you go to from 9 to 5, Monday through Friday, in order for you to be eligible for an apartment. It is absolutely what they do. And so this one of the programs, in addition to helping people when they have experienced discrimination, the Springfield Fair Housing Project also has a fair housing testing program. Fair housing testing, I don't have anything on here, but it's topical, so I'm going to start talking about it. Fair housing testing is a method that we use to evaluate housing providers' compliance with fair housing laws, where we evaluate a housing provider's everyday business practices. So we train individuals, community members such as yourselves, to pose as bona fide as renters. We assign you characteristics. You want to play with me? Great, awesome. I would love to have you. Please come test for me. We assign individuals characteristics. We send them out to a housing provider. They interact with that housing provider totally as neutral as you can. You come back, tell me what you experienced. And if there is evidence of discrimination, there are some proactive ways that organizations like CLA through the Springfield Fair Housing Project can hold landlords accountable for their behavior. Filing complaints with the Massachusetts Commission Against Discrimination. Filing complaints with the, oh my goodness, Housing and Urban Development, which is a federal agency, and more, Housing Court, all of that good stuff, to kind of hold housing providers accountable and seek better treatment in their business practices generally. So that's one way that we can proactively work on combating housing discrimination in addition to addressing issues that people have already experienced. Yeah, absolutely. Go ahead.
Yeah, I want to, if you know anything about this, but obviously regarding the housing crisis, where LLCs, which I also consider the beast, how are they able to get away with raising the rent, especially in places like Holyoke, where people, are below poverty line, people of color. Huh? Right, but how are they getting away with that? Like there's no rent.
They are.
We've allowed housing to be a commodity.
Yes, exactly.
I
guess what I should have asked. What can be done? What do you think?
Yes.
Are you guys looking into this?
Yes, we are. So, there are instances where the example I used earlier with raising the rents and serving notices to quit or being unwilling to negotiate a new rent with only individuals who have housing vouchers. We heard about that. And that's not okay, and so that's in court right now. There are those kinds of situations kind of require a two-way communication. We can't do anything if we don't know about it, right? So we would love to hear if something fishy is going on, or you're not being treated well by your landlord. It might not fall under the fair housing laws, but it also might, and we would love to talk to you more about that. That's where the, kind of broken record, please talk to a lawyer situation comes in. There are things like that. There are things like housing testing, sending testers out to these large developments to seek apartments and housing, and kind of having them report back based on what they experience.
Part of the problem is if one development's getting away with charging these things, even if they're illegal, others, it's like they just keep increasing each other because they realize that exactly. So if we can start to target at least the ones that are illegal and make sure that they're not doing it illegally, it can help a little bit. But as others have said, there are some legislative efforts that are making some headway. And I know you had your hand up.
I know I do, and then Nev does. But I have a question around so I've talked to a lot of renters. I am a tenant. Conversations around being discriminated against are plenty.
Yes.
Right? Like whether it's family size, whether it's income, disability, all of that. I wonder if y'all have an idea of like how many people actually come to you versus how much is actually happening. And I ask that because we need housing, right?
Yeah,
like
100%.
I could be like, yo, I'm being discriminated here against, but they gave me an apartment and I'm on to live in my life. Do you know what I mean? So like there's a disconnect between.
Absolutely. Absolutely. I mean, the short answer is we don't know how much discrimination is actually happening. What we feel incredibly confident saying is that we only see a very tiny, minuscule fraction of what happens. So there is infinitely more discrimination that happens than what we hear about. And we would love to hear more. I think that's part of our outreach efforts. That's part of our attempt to recruit testers. If anybody in this room, by the way, wants to be a tester, please contact me. Yes, I love this.
Follow up, and I know, I'm sorry, of those that actually come to y'all, right?
Yep.
Say it's 3% of people how many actually get resolved? How many landlords are actually being held accountable? How much capacity does the state have to pursue those things? Or is it like, bad landlord, keep it moving?
Yeah, I mean, so the housing, as you've kind of heard a little bit about, these housing cases take a really long time. So the number of cases that we take depends on capacity, depends on how complicated how complex a case is. It might be that that an individual needs a reasonable accommodation request, and that's kind of like what they need, and that's it, which might not lead to that like more equitable relief or changes in business practices, for example. But if you look on if you look on like Craigslist or housing ads, and there's language there that's like, we don't discriminate based on family size, no, like they're not going to put that in there unless they were told to, which probably means that somebody has sued them or held them accountable for something. And it's like part of the resolution for that case was you can't, and you have to say that you're not allowed to do that. So there are some things like that, but as we're seeing, even the landlords that have we accept support animals and service animals still don't. And that's the problem, right? Because they keep getting away with it. And so part of what we're trying to do is increase awareness of what rights are, so that more people can hold their landlords accountable for the problematic behavior that they do. Because as somebody in the back mentioned earlier, like group collective action is what is going to change behavior. One person kind of coming, even with the most compelling case that ever existed, that landlord is going to be like, well, it's the cost of business, so whatever.
And you just one of the most important takeaways they said earlier is you just have to trust your instincts. If you feel like something is discriminatory, there's a chance that it is, and we're all kind of in our lives taught to go, I should just deal with it, or maybe it wasn't what I thought it was. It probably was. So call us, talk to us, even if it's not something that's actionable in the moment. Trusting those instincts and banding together and talking to your neighbors and talking to legal aid and building this collective understanding will really lead to the change.
And it can also lead to pattern spotting. So those individuals who were given notices that had vouchers when nobody else in the building kind of did that, they knew that was a pattern because they talked to each other. So talking to your neighbors, talking to other tenants in your building, talking to people on your block. I mean, landlords own a ridiculous number of properties. Like chances are they own like 15 other houses. But talk to people. Maybe there's more than one person that's experiencing the same thing, and the more people we can have that are having these problems, that leads to a much more it's a little ridiculous to say, but legally in court, it leads to a more compelling case if you can say that this is a pattern of behavior and it's not just a one-off incident. Somebody over here had their hand up for a while.
I would like to follow up with one of the questions, which is what exactly does accountability look like when you say holding landlords and these property owners accountable?
Yeah.
And also regarding the possibility of rent control somehow, do you have a vision of how to get that started or what it would look like?
So to the first, what does accountability for landlords look like? It depends. I can give you some examples. So in an individual, if somebody comes to us and complains about experiencing discrimination, accountability can look like they are not evicted. Accountability can look like they actually have to make the stinking repairs. Accountability can look like not only do they have to make repairs, but they also have to pay you 3 times whatever the money is, because that is a protection that you have. That's something that the consumer protection laws provide, depending. Also, caveat, some landlords are not held to the fair housing laws because their properties aren't big enough. So also that sucks. And so if you
keep in mind that a lot of what we've said does come with some of these caveats. So things like 93A, for instance, might not apply.
That consumer protection.
The consumer protection one. So when we talked about documenting those conditions, taking those photos, bringing them to court to make those complaints, sometimes the smaller landlords may not be subject to some of the laws, including those, for instance, that require them to pay you 3 times your rent for certain conditions and certain damages. So it's just really, really important to try to connect with a lawyer, get some legal advice, read up on it. Unfortunately, there are a lot of these carve-outs that can make it a little bit difficult to hold all landlords accountable, but we just want to make sure that you guys know what they are so that you can kind of pursue those more. The most important thing, you know, as we've been talking through this, is making sure that you're safe and that you know what your rights and options are. You can always call us for more advice.
I'll add just briefly to the accountability that some people, when they're in court against their landlord or their landlord trying to evict them and they pose counterclaims, tenants can ask for changes to business practices. Tenants can ask that you don't do what, you don't deny reasonable accommodation requests. And if that's put in your agreement in court with the landlord, and then the landlord does that again, they're gonna it's gonna be easier to get them in trouble for doing that. So there are ways that you can individually also push for housing practices to change.
Who will you go, where do we go to do that? Because
Court.
I think this is, even though we have that, listen, Holyoke have people that work at, I think the minimum, minimum wage. There's few that are blessed, are able to get $20 or a little, all that. But even with $20, they still barely making it by check. But with these people that are in the middle of the minimum wage or the little $20 that we get, I mean, sheesh, that's not even enough for the 3 times the income. Or what are these guys are getting enough?
Yeah, well, the 3 times the rent is just there's one of the things that a landlord isn't allowed to do is post advertisements for housing that are discriminatory. Advertising that a tenant needs to have 3 times the monthly rent is what it's called facially. It's it's on its face. You can read it right there. It's in writing. It's discriminatory because that shuts down applications from individuals with Section 8 or things like that.
They do it, though.
And they do it, yes. So part of what programs like ours are doing is trying to hold them accountable. It just...
I realize most of these landlords, right, now they're getting managers to run their companies, right?
Yep.
So people like you, when we go to court with guys like you, instead of going against the landlord, we're going against the building manager. And that's really who we supposed to be going after is the landlord, not the building manager.
Well, you can...
He's being told what to do.
So you can... The owner of the property, the landlord, is also accountable for the behaviors of the people that they hire. So if a landlord has hired a management company to manage their properties, and the management company is discriminating against people or is not following the law, both the management company or whoever within the management company is acting poorly, and the owner of the property, the one who hired them, who's responsible for their actions, are both accountable under the law for following the law. Because it's the owners, if you're gonna do that, if you're in the business of housing and you hire somebody to do that, then you also need to do your due diligence to make sure that people are following the laws. Yeah?
So you touched a little bit about, and this is a really great transition into class discrimination.
You mean like class action?
No, class discrimination.
Socioeconomic, thank you.
Yeah, and so I was wondering if you could go a little bit more on that basis on the record, and also since there's not really anything I feel, or that I come to the conclusion that there's not really much to protect us against class discrimination in Massachusetts. That's why folks are interested in rent control so very often. What is something that we can strengthen within Massachusetts, and how can our local representatives, alongside any governing bodies, might be able to assist with strengthening this kind of essentially any power?
Yeah. So the easy answer is that source of income is always there. It doesn't just have to be Section 8. It can be like if somebody receives disability income or Social Security income or things like that. They can't be denied housing opportunities, or they can't have misrepresented terms of your tenancy for somebody who's receiving a different income than somebody who like works and makes six figures. Congratulations to you. That's nice, but you still can't do that. Kind of different treatment. So that's a disparate treatment situation where an individual is being treated differently than other people because of this thing. There's another kind of group, and this is one way that lawyers can kind of get around some of like the federal fair housing protection does not protect source of income. But Housing and Urban Development says, excuse me, there is a disparate impact, there is a disproportionate impact on marginalized communities because they are predominantly the ones who receive those kinds of benefits. So, on the basis of race, like the racial minorities disproportionately receive Section 8 or mobile vouchers, or are likely to be on, like Social Security income or things like that. So there is a way that kind of collectively individuals can prove that they are being treated differently, not because of like the actual interface with them, but because landlords' practices are having a disproportionate impact on members of a protected class. That saying 3 times the monthly rent has a disproportionate impact on communities of color. That would be one way to go about it, or things like that. That is like it's just less easy to do in court than pointing to like this individual was treated differently because of their housing voucher, and we can like point to that very clearly. One of those persnickety caveats is that community legal aid is prevented through funding from doing class action suits. But our subsidiary is not, which is nice. So that's a CWJC kind of thing. And there is, unfortunately, like our unit can only do so much, and there are so many like Band-Aids to slap on things that some of these more involved cases we might need to refer out to different, maybe private lawyers who have a little bit more capacity. But we still really want to hear about it, and we still want to kind of talk to you about what is going on and what your options are, because that is a problem, and there is that disproportionate impact on communities, and socioeconomic status is just,
Yeah, and the other thing is there are limits to what you can do in an individual case. So we do represent tenants. It does make a difference when you are able to exercise your rights and educate landlords and educate your peers. But the other things you can do are things you're doing right now, like working with community organizations, organizing with each other, inviting your electeds, and talking to them about what you're facing and what you want to see. They're here to work for you, so it's important for you to make sure that you're constantly telling them what you're experiencing, because maybe they don't know. So you're already on the right track with all of that stuff.
Can I just go for it? I actually wanted to answer Cocaine's question about like rent control. How do you get it started?
Yeah.
This is how you get it. This is how you get it started. You invite your like exactly what these really incredible people said. You invite us and you advocate to us and you put pressure on us because it's a legislative fix. So.
And then Neighbor to Neighbor will also be having a housing meeting tomorrow, 3 o'clock at Nueva. If anybody wants to talk more about rent control, how we're going to win it, things like that. Just plug in that.
And then I'll expect to hear from you.
I have a question about housing records. I'm not sure how, it's been a while since I used to do housing search, but it's been a long time. But like the housing records, how do you protect yourself from, like let's say, especially with today's economy, from if you had an eviction in the past, how do you protect yourself from having a negative housing record on top of everything else?
Yeah, unfortunately, that's one of the the legal reasons why a landlord can deny your application for housing is if you show up in the housing records, kind of like no matter if you had an eviction or filed against your landlord or weren't even.
Can you repeat repeat, like, even if you're a plaintiff?
Even if you, yes, so even if you're like, I want to hold my landlord accountable for that really awful behavior that they did, and you go to court and file without having a case already against you, that will still show up in your housing records.
We're working on that. I was going to say,
Thank you.
Thank you. There are initiatives that, like ballot measures and bills that are being drafted constantly to try to address this problem. They may not pass the first time, they may not pass the second time, but people are working on these issues. So if you want to get involved in that, again, that's a great way to advocate with your electeds and get some protections in place so that those things go away.
As well as Corey Sponge?
Corey, that is, so CLA also has a Corey unit, a Corey reentry unit, and that they are also working on that. That can also be, there's literature up here. There are ways that we've gotten at housing discrimination challenges when somebody's like Corey, for example, was for drug use or DUI or something like that. We can kind of connect it to substance abuse disorder or some other thing, get it in through a disability lens. So there are options, and there are lawyers who are working on that. Yeah.
Oh, sure. I was wondering, we've had situations in the past where you talked about the Board of Health condemning the building. Then you said the Board of Health is supposed to take the landlord to court. How quickly is that supposed to happen?
It depends on the situation, and I know that's not the ideal answer. I don't have off the top of my head, maybe Joel, you know how quickly they're supposed to bring landlords to court in a condemnation case?
Yeah, well, condemnation is an emergency thing, so mostly what happens is they will go to court very quickly after a condemnation. But in a regular, you got bad conditions and the Board of Health takes you to court, that can be a long process.
Yeah,
that doesn't happen.
So I have another part of that question. So we've had here in the city the condemnation because of uninhabitability. The landlord refuses to pay. I've read on one of the the legal housing websites, it says, at that point, when the landlord refuses to pay, the tenant has the right to take the city to court because the city's the condemner. The city will pay to put them up in the hotel, and then the city should go back and go after the landlord legally. Is that correct? Is that the way the process is supposed to happen? No. It says on the website. I mean,
there is a relocation benefit that's arguably available under federal law, but in general what happens is, and the court's good about this, if you're condemned, the housing court will force the landlord to put you up.
Right.
So you have to get in front of court, so it's not the easiest thing to do, but yeah.
Right.
Yeah, that's why, it is so important to call the Board of Health, and I want to clarify what I said earlier. We never want you to leave anything unsafe. Thank you for pointing that out. So if there's things that are unsafe in your apartment, don't just leave them. You can clean those up and take photos instead. But we want to make sure that you're constantly communicating with the Board of Health because things can be delayed. So if you've had them come and your landlord's not making repairs, keep calling the inspector and keep doing things like that. It can unfortunately take a while, and it can be delayed. And we know it's really hard to live in these conditions, in these situations. But if you can stay on top of them and use them as a resource, and hopefully once they get into court, then you have the right to ask the court for remedies that you need. So if you don't have somewhere to go, you can ask to be put up, and they can, in some situations, do that for you. Document everything, yes.
There's an additional thing that we wanted to say on that question that was over there on the basis of what can be done about the negative housing record. Katie has a really good point on this, on why it's important to have the kind of tenant self-help.
Yeah, so one, I want to highlight that there was a Homes Act put forth last year that would both put an end to how far back a landlord can go. 7 years, that's it, right? That's it, 7 years. And it would remove all of the plaintiff, right? The plaintiff and the no decision, right? If there was no decision made, y'all came to a mutual agreement, it would seal all of that. Also, a resolution was put forth here in the city of Holyoke in order to have the Homes Act implemented here in the city as well. Some of the things that we have been trying to work on is a tenant bill of rights, right? Which would also further further expand our rights as tenants, both around our quarries, right? Both around our housing record, how we can be treated, things like that. You know, and that is why these conversations are so important, to bring up the gaps. The gaps, we live in a state that comes off as a tenants rights state, right? We live in a state that looks like that. But if my house catches on fire, it's on me to figure out where I'm going. My landlord's not responsible. The Red Cross ain't responsible either, you know? If there's issues, the only avenue I have of accountability is going to screw me in the long run to find another place. So yeah, I just wanted to, did that cover it?
Tenant of office protections.
Oh, the Office of Tenant Protections. Yeah, so one of the things we're also putting forth is the need for an Office of Tenant Protection, which would have a landlord registry, but would make it so there's a proactive inspection happening for every rental unit every 2 years. Right? Like, or every time a lease changes over, like we are going into those buildings to make sure that they're up to code. So it's not always on the tenants to know where to go, who to talk to follow up, right? Like let's think about who's tenants. It's like working class, poor folks, right? Single mothers. Like who has the time to keep calling the Board of Health to be like, come get my shit, come get my, you know? So implementing some of these larger protections would really help prevent some.
Great. Yeah, so this is also something I want to point out is that these folks are a great resource, and make sure that you're using them and talking to them and talking to each other, because sometimes, you know, your individual situations can be remedied with a lawyer's assistance, but sometimes it really will take more mobilization and these kinds of efforts to put in the structures that are top down to make sure that there are ways to enforce it that don't require you, as we talked about, consistently going to court. But we're here for you in the meantime. But we love these efforts to make change, and also we come because we want to hear how we can be more helpful to you in your individual and your collective needs. So part of this is just to make sure that we're being a resource for you. And
yeah.
So, considering that there are buildings in Holyoke that we know of that have these issues, regardless of which tenants live there, is there any way that a person can advocate for a tenant in those buildings without something showing up on like a housing court, you know, like a negative tick for them in housing court?
Yeah.
Because there are definitely buildings that have problems all the time. They come up all the time. They're like the worst, the worst offenders.
Yeah.
Is there a way to deal with that without having the individual tenants have to deal with it themselves?
Yeah, so I mean, I can only speak to the discrimination lens because that's what I do. But there are ways to file cases not in housing court. So like the Massachusetts Commission Against Discrimination, caveat, like the problems have to be related to discrimination in a compelling way, or like letting a housing building run down because they know that the people who live there are like, don't have status or whatever it is, and so they're just kind of being the worst. You can file those complaints with MCAD or with HUD or things like that. Cease and desist letters, demand letters.
If there's subsidies, you can work through the housing authority sometimes. So like if you have a voucher, sometimes your voucher provider might be able to get involved and put some pressure on the landlord. There are pros and cons to those strategies too. You can organize with other tenants in your building and try to, aggressively encourage your landlord to recognize the issue and take steps before you take some kind of a collective action. All of those things are options. There are, pros and cons. Your landlord might react in ways they're not supposed to react, but retaliation is illegal, so you do have defenses even if there's a court record. In the back.
I've been dealing with the Board of Health for months now with our landlords because nothing in our building is up to code. We've already had the building inspector there. They've had a no work order. Now that they got permission to do work, they're still doing things illegal. And they're doing things half-assed. I've been there since 2019. I had no heat for 2 years. And I was pregnant.
That's
We
awful.
just now recently got heat and it's still considered illegal because
Mhm.
It's not enough.
the duct heat. the
Oh, yeah.
Air duct heat. They got all the metal showing,
Yeah.
not in the ceiling.
Yeah.
And it gets mad dry in there. And then the water pressure sucks.
Mhm.
My water, the pipe is about to burst. And it's like our landlord don't care.
It's
He
really,
got all
really
these
frustrating.
fines and everything else. And it's like, all he cares about is I want my rent.
Yeah.
It's like, do you not understand there's children that live in this building? My son is the youngest child in that building. He's only 8 months.
Have you talked to a lawyer at all? Have you called any lawyers?
I talked to a lawyer when I was at the city hall.
Okay.
It might be worth either calling our offices or talking to a lawyer just to see what legal steps you might have. I mean, we've been talking about the limitations
And on
of
top of all that,
court,
I had
but
a lead issue too. He tried using a lead certificate from 2005. and
Yeah,
they
so
told-
it sounds
they
like-
told him, oh no, that's not gonna happen.
So lead problems are housing discrimination claims if there's a child under 6.
I have
So,
3 children under 6.
yeah, so
A 5-year-old, almost 3-year-old, and an 8-month-old.
yeah, so a refusal to de-lead or
Oh, they
whatever.
supposedly
Yeah.
put us in a hotel and supposedly de-leaded everything, but it's kind of funny how they de-leaded because everything's still peeling.
Yeah, so that's like textbook familial status discrimination, which is one of those classes under fair housing laws, under both state and federal laws. You can't do that.
I can still take him to court for that.
You can still take them to court. So that yeah, you can still take. Yep, you can still take them to court. Yep, you can take them to court for that, and you can also call us and we can talk to you about familial status discrimination.
Give us a call. Our cards are out here. You can call the intake line and tell them some of what you told us, because it does sound like you're having some problems specific to your unit that are in violation of the code. So definitely give us a call and see if someone can
the
help.
inspector that came in and inspected the whole building told us that everything in the building is all, it's not up to code or
And
nothing.
we're here to help you.
Right
We're
now
here to
there's-
help elevate your voices, right? It's frustrating, but sometimes maybe these folks are not able to listen to you as much as if you have a landlord, as if you have a lawyer calling. So it could be worth getting one of us involved. That's what we're here for, is to help you lift your voices and make these systems work more effectively the way they're supposed to work for you. So definitely give our intake line a call and
It just
see if
gets
we can
annoying
help.
when he's younger than me, but he acts like just because he's a landlord, he knows more than me. My
Yeah.
husband's actually going to school for the building code.
Oh, well, there you go. That's a good proactive step to take.
He's
That's
going for his
awesome.
license.
I saw another hand in the back.
Oh, yeah,
Yes.
I just, well, I like, put my sister, so I'm only gonna say one thing.
Okay.
But in regards to, you keep saying to like, reach out to the Board of Health, reach out to the Board of Health. But like, I did reach out to the Board of Health and I thought I did the right thing, but then, it was like my mom and I's apartment, and she has a disability, and so they didn't renew the lease. And then also when the Board of Health came and they gave them the violations that they had to repair, all the repairs were incredibly shoddy. Like the kitchen faucet was like a box heater, some sort of like Loctite lid, and like there was like a leak, and they, it's just like they didn't need to do anything. They just like I don't understand how that passes.
It shouldn't.
You're asking a place to live.
Yeah, it shouldn't pass. That is not an effective repair, and so that they haven't done the repairs, essentially. And if there's an individual in your household with a disability, there are potential reasonable accommodation requests that you can make that then kind of engages in this you are now legally required under fair housing laws, in addition to putting things up to code to make repairs, to accommodate disabilities, to not renew my lease because of X, Y, or Z, that kind of thing. I mean, depending on the reason why they didn't. Oh, that was something I wanted to say. Landlords will say that they're doing things because for reasons that sound fine, but they're not. So even if your landlord gives you a notice to quit or starts eviction proceedings against you, or otherwise changes the terms of your lease or does anything that they're not supposed to do, and they say that it's just for a reason that is legal, that it doesn't necessarily mean that's the case. So let's talk more about that.
And keep up this work. Again, with the organizations, we are seeing some very slow changes to the state sanitary code to improve what it includes. For instance, they're revising it this year to include some things. So in addition to taking individual steps to improve your specific situation, continuing to organize, to talk to other tenants and to talk to your electeds to try to make changes from the top down so that things in the sanitary code that might be minimum standards that to us don't feel sufficient can be tweaked over time to be better. May not help right away for your specific situation, but make it so that we're making lasting and impactful change. Thank you for that, Beth. Appreciate it.
All right.
Questions? No?
Thanks so much for coming.
Yeah, thank you guys. Appreciate it.
Is there anything you want to add based on, because you're like a private practice versus a government-funded practice?
Oh, no, that's 100% correct. 100% correct.
If there's anything you wanted to add from your experience or avenues that you may be able to tell people we have versus
Yeah.
funded.
Yeah, I guess I was just.
Or not, I mean.
Sure, no. We're in Springfield. My name is Joel Feldman. And our firm's been operating for 25 years in Springfield. And we're available to you to do especially cases in which you have bad conditions and you want repairs and also you want compensation for it. In other words, if someone asked before, oh, I get the repairs, but I'm really mad, and I want to get paid back for the suffering I put up with. So we do those kind of cases. So, happy to be another resource to people, really, more than anything else.
Thanks, Joel. Thank you so much.